Welcome to this comprehensive technical analysis and comparison of the two most powerful offshore asset protection jurisdictions in the world today, which are the Cook Islands and Nevis. For high net worth individuals in 2026, the threat of aggressive litigation, astronomical court judgments, and the potential for asset seizure has never been higher, leading many to seek a legal fortress that exists outside the reach of domestic court systems. While many offshore locations claim to offer protection, only the Cook Islands and Nevis have consistently demonstrated the legal fortitude necessary to repel determined creditors through decades of tested case law and robust statutory frameworks. In this guide, we will explore the specific mechanisms that make these jurisdictions unique, compare their costs and operational requirements, and help you determine which structure provides the best defense for your specific financial profile. We begin with the Cook Islands, which is widely recognized as the birthplace of modern offshore asset protection legislation. The Cook Islands International Trusts Act, originally passed in 1984 and refined most recently in 2022, was the first law of its kind to explicitly prioritize the protection of trust assets over the claims of foreign creditors. The foundational strength of a Cook Islands trust lies in its total non-recognition of foreign judgments. If a creditor wins a $20 million judgment against you in a United States court, that judgment is essentially a worthless piece of paper in the Cook Islands. To reach your assets, the creditor must travel to the South Pacific, hire a local attorney at a significant upfront cost, and relitigate the entire case from scratch in a Cook Islands court. Furthermore, the Cook Islands imposes a standard of proof that is almost impossible for a creditor to meet. In a domestic civil case, a creditor only needs to prove their claim by a preponderance of the evidence, which means it is more likely than not that you are liable. However, in the Cook Islands, a creditor must prove that you transferred assets to the trust with the specific intent to defraud them beyond a reasonable doubt, which is the same high standard used in criminal murder trials. This legal hurdle, combined with a very short statute of limitations of only 1 to 2 years for fraudulent transfer claims, makes the Cook Islands the ultimate choice for those facing significant, high-stakes legal threats. Now we turn our attention to Nevis, a small island in the Caribbean that has emerged as a formidable challenger to the Cook Islands. The Nevis International Exempt Trust Ordinance provides a set of protections that are very similar to those found in the South Pacific, but with a few unique barriers that some investors find even more appealing. The most significant of these is the mandatory $100,000 bond requirement. In Nevis, before a creditor can even file a legal challenge against a trust, they must first post a cash bond of $100,000 with the Ministry of Finance. This bond serves as a massive psychological and financial deterrent, as it is forfeited if the creditor loses their case, which, given the high burden of proof, is the most likely outcome. Nevis also offers a great deal of flexibility in how its trusts are structured, particularly when used in conjunction with a Nevis limited liability company. This hybrid structure, often called the bridge trust for the asset protection stack, allows you to maintain day-to-day control over your assets through a domestic LLC that is owned by the offshore trust. If a legal crisis occurs, the offshore trustee can step in and move the assets to the safer jurisdiction, effectively pulling the bridge up behind you. When comparing the two head-to-head, the decision often comes down to balance between reputation and cost. The Cook Islands is considered the gold standard because of its 40-year track record and the absolute consistency of its courts in protecting trust assets. However, this level of security comes with a higher price tag. In 2026, Setting up a comprehensive Cook Islands trust typically costs between $20,000 and $30,000, with annual maintenance and trustee fees ranging from $5,000 to $10,000. Nevis, on the other hand, is generally more cost-effective, with setup fees typically falling between $12,000 and $18,000 and annual maintenance between $4,000 and $9,000. For individuals with $5 million or more in liquid assets, the premium for the Cook Islands is often seen as a small price to pay for the ultimate peace of mind. For those in the $1 million to $3 million range, Nevis offers an incredibly high level of protection at a more accessible price point. It is also vital to understand that in 2026, Nevis jurisdictions is a place to hide money from the government or avoid taxes. Both the Cook Islands and Nevis are fully compliant with international transparency standards, including the Foreign Account Tax Compliance Act and the Common Reporting Standard. This means that while your assets are protected from civil creditors like former business partners or medical malpractice plaintiffs, they are not invisible to the Internal Revenue Service. You must still file your annual Forms 3520 and 3520, as well as your FBAR and FATCA disclosures. A legitimate asset protection trust is built on transparency with the government and total opacity for creditors. By being open with the tax authorities, you strengthen the legitimacy of your trust, making it even harder for a creditor to argue that the structure was created for an illegal purpose. Another critical feature shared by both jurisdictions is the duress clause. This is a specific provision in the trust deed that prohibits the trustee from making any distributions or following any instructions that are given by the settlor under legal compulsion. If a United States judge orders you to bring your offshore assets back to pay a judgment, you can truthfully inform the court that you requested the funds, but the offshore trustee refused because the request was made under duress. Since the trustee is not subject to the jurisdiction of the United States court, the judge cannot compel them to act, and as long as your trust was properly structured and funded before the legal claim arose, you are protected by the legal doctrine of impossibility. This mechanism has been tested multiple times in high-profile cases, and while it requires you to give up a degree of direct control, it is the most effective way to ensure that your wealth remains intact when your world is under attack. In conclusion, the choice between the Cook Islands and Nevis is a choice between two of the most sophisticated legal tools ever created for the preservation of wealth. The Cook Islands offers the weight of 4 decades of legal precedent and a reputation that often causes creditors to settle for pennies on the dollar without even attempting to litigate. Nevis offers a unique financial barrier in the form of the $100,000 bond and a highly flexible, cost-effective environment for modern estate planning.